Well, that was the government counsel there, Mohan Parasaran, taking us through what is expected in terms of this renegotiation. Joining us now, Hitesh Jain, partner at ALMT, Pradip Baijal, former Special Secretary in the Ministry of Power, and R.S. Pandey, former Oil Secretary. Gentlemen, many thanks for joining us this evening. Hitesh, let me start by asking you, because you were on our show last night, and this is pretty much what you had expected, that the Supreme Court will uphold the gas utilization policy, will uphold the production sharing contract, and that will reign supreme. So pretty much according to expected lines as far as you're concerned.
Yes, as I'm reading the judgment in greater detail, it is on the expected line. The legal position as regards binding efficacy of the MOU was very clear. There was a previous judgment of the Supreme Court, which the Supreme Court has relied in the Rangaraj case, that private arrangements arrived between the shareholders are not binding upon the company. So that is also on the expected lines. As regards NTPC also, this judgment is not going to affect, because that has also been left to the EGOM and the government. So the judgment, according to me, is on the expected lines.
Okay, Hitesh, before I move any further, one quick question really, because the Supreme Court has asked both parties to actually go back and renegotiate and come back, within a period of 6 to 8 weeks and put together a new renegotiated pact. We just heard Anil Ambani talking about it. The Supreme Court in its order says the tenure of such contracts cannot be such that it vitiates the development plan as approved by the government. Therefore, the GSMA and the GSPA entered into with Reliance RNRL should fix the price, quantity and tenure in accordance with the production sharing contract. So what room really then is there for renegotiation? How do you see this renegotiation roadmap? Because Harish Salve, the Reliance counsel himself, is unsure.
Guidelines have been laid down by the Supreme Court. As far as RNRL is concerned, they would look at two guidelines which has been observed by the Supreme Court. First is interest of RNRL shareholders as reflected in the MOU, and second is overriding public interest. It is possible, like on the ground, that to promote the industry, to promote the power sector, the Supreme Court, if suppose some concession has to be made in terms of price, and if the parties agree at a unanimous decision and the government feels that it is in the overall public interest that the industry has to be promoted, then there can be some room of maneuvering. I don't see any. There are so many grounds on which, as enumerated, one can really look as to negotiating table.
Mr. Baijal, what have you made of the verdict, particularly that it restores the sanctity of the fact that the government is the sole owner of the gas and that government policy overrides any private contract?
Yes, it's a very powerful judgment. It says that private arrangement or a family arrangement or a MOU cannot overtake public policy. And it is very important that public policy rules over such arrangements.
Right. Mr. Pandey, let me bring you in, because, you were Oil Secretary during a large part of this battle, sir. Has the verdict in that sense brought in the much-needed clarity that the government, as Harsha was pointing out, is not just the owner of the gas, but also has the power to decide on pricing? Do you think the government stands vindicated today at the end of this battle?
Yes, the Honorable Supreme Court, after saying that the government is the owner of the gas, they have also said that the production sharing contract overrides all other private arrangements, including the MOU, which was the subject matter of the case. Under the PSC, government has the right to fix a pricing formula. Government has the right to have a gas utilization policy, and all these have been upheld by the court. So this clarifies doubts. If there had been any, in the government's mind there was no doubt at all, but there were lurking doubts here and there. So that has been set at rest and the position is very clear.
Hitesh, let me come back to you, because, right as we speak, Mohan Parasaran is speaking to one of our colleagues, has just said that the case as far as NTPC is concerned is different. This is what we were discussing even yesterday on how this judgment is actually going to impact the current battle that's on in the Bombay High Court between Reliance and NTPC. And Mohan Parasaran clearly suggesting that the yardstick there is different, because NTPC is an instrumentality of the state. The profits will actually go to the government, and hence this should be treated differently. Your comments on that?
NTPC can derive a support from the judgment because the judgment clearly states it is the government who's the owner of the property. Now, NTPC being a government arm, it gives a right to the government to discriminate and give a concession to NTPC. The government can justify such concession. The government can justify that this is not a discrimination. And NTPC being an own entity, the government can say that if we are selling to our own arm, we are entitled in public interest to sell at a reduced price also. So even if the government fixed that for the private purchasers the price will be X and for the government entities it will be lesser, the government will be right in doing so.
Mr. Baijal, could a different set of yardsticks be used as far as the issue with NTPC is concerned? And from a government standpoint, what could be the change situation?
You see, while it is absolutely correct that the instrumentality of the government can be charged a concessional price, but it creates a plethora of problems in regulation. After all, when you liberalized the private sector companies which entered the telecom network or the power network or the gas network, now they have to have a level playing field with the public sector companies. So if you come up with a thesis later that the public sector companies have to be given a concession in the price, then it will lead to a number of questions and perhaps a determination later that their power price will also be different if they get the resources cheaper. And that will be a very difficult arrangement to sustain in the long run.
Mr. Pandey, just a point about what the Supreme Court has asked the brothers to do. It has asked them to go back and renegotiate the contract. You know, to your mind, what could be the scope for renegotiation?
Yes, we have really not applied our mind to that. We were not really concerned about what the two private corporates would be doing amongst themselves, but it's a good thing if they could sort out their dispute through renegotiation. There is nothing like that. In fact, this was one of the options given by Bombay High Court also. If you see carefully, there were 4 options, and the last 2 options about having a new set of agreements or asking for damages, etc. So I really do not know how the renegotiation will be done, because I've not gone into their entire dispute. And but this is a window through which they can sort out their differences, and that is welcome.
Right, Hitesh, you know, we've already heard Anil Ambani saying that they're not looking at filing a review petition, at least at this point in time. But how, you know, what is their thinking going to be, as, you know, to your mind? Because clearly the family MOU was the basis, was the foundation of the division of assets between the two brothers. Clearly the gas agreement between the two as part of that family MOU was done at a certain valuation. Now that does not stand anymore, it puts into question the division of assets per se. So what would you think would be the thinking as they enter into this renegotiation as part of this larger family MOU, which even Harish Salve says the court has upheld, could perhaps be the guiding principle?
I think as one reads the judgment in detail, it becomes clearer and clearer. The judgment explicitly states that the court cannot rewrite the scheme of merger again, and the court cannot rewrite the MOU. Secondly, the Supreme Court in express word has also observed that it is the discretion of the EGOM and under the PSC for the government to decide the pricing issue. So one thing the Supreme Court has clearly left, that no courts in future can get into this aspect of fixing the price, because the Supreme Court said we do not have an expertise to come to a suitable arrangement or fix the price. It is the prerogative of the government. Now, with these 2 clear guidelines, when they sit on the negotiating table, one is clearly aware about what his rights are there in the future, and therefore, one can see that the Supreme Court has paved the way for the parties to sit together and come to the negotiating table.
All right, Mr. Baijal, let me come back to you, because what the court has also said is that it is high time that the government actually puts a suitable utilization policy, a suitable gas policy in place. Now, Hitesh is already talking about the fact that the court doesn't want to intervene in future. It's going to be left to the government. It's going to be left to the empowered group of ministers. There was a question on whether it should be retrospective or not retrospective. The court has clearly delivered its verdict on that front. You know, we've already heard from our sources that in the past fortnight or so, Reliance Industries has asked asked the government or stated that, even $4.32 or even $6 is not viable anymore. So how do you actually expect now the government to approach this entire issue of pricing a national asset like gas?
You see, these are very complex issues. Now, the prices of gas change the world over. The prices, we import gas, we import other sources of energy, we import naphtha. Now, to say that the Indian indigenous price for some reason will be very different is not sustainable. You can't have a very low indigenous price and a high import price, because that would lead to a situation that the importers will get a much higher price and the indigenous producer will get smaller price, which will inhibit his ability to invest further in getting resources in India. And that is very important, that the price should be fixed by the government, but the production sharing contract very clearly says that it should be based on commercial principles, and that is what the government has done. Now, as the volatility increases, or as the problems increase, or as you find resources which are very expensive to explore, but yet you see that the world prices have gone up, maybe the government will have to take a view, and that is precisely what the Honorable Supreme Court has said, that we leave it in the area of government, and the government and the experts will sit down together and decide on these issues. They can't be issued, these issues cannot be sorted out very quickly. They'll need a lot of deliberation.
All right, Hitesh, there is a stipulated period between which these two brothers have to actually arrive at a renegotiated pact. Now, and this is only in the realm of speculation, if indeed they cannot arrive at a renegotiated pact by that time, what then is the future course of action, or what then happens really to where things stand?
Well, according to me, 6 or 8 weeks cannot be sacrosanct. If the parties need 12 weeks or 2 months or 3 months, and if the parties think that they are closer to the settlement, they can try and explore in the extended time. In view of the guidelines, I think the parties would try to achieve the settlement as expeditiously as possible, or wait for the settlement. And if the settlement is not possible, then the parties are, the court said that if you have to come with a suitable arrangement and go back to the company court, so then the parties will be back to the courts.
All right, General, we'll have leave with Hitesh Jain, Mr. Pradip Baijal, R.S. Pandey. Many thanks for joining us on this edition of What's Hot. Coming up next,